Good afternoon, guys. Good afternoon, and welcome to today's edition of The Law and You. I'm your host, yours truly, attorney at law, licensed in the state of New York, also licensed to practice law in Guyana and Trinidad. I'm Shellon, Washington. Also, the owner and founder of the Washington Law Firm, which is located at 455 Utica Avenue in Brooklyn, New York. For those of you who are watching, I encourage you to go to my Washington Law Firm's web page or Facebook, I'm sorry, my Facebook page, and click the like button. And also for those of you who are enjoying this content, I encourage you to make sure that you click the share button and share this content, like the video, and ensure that you share it every single week so that people who might be in need of this valuable information, which I share every week at 4 o'clock every Saturday, they will be able to make use of this information, and maybe they might need legal advice. The phone number to call is right there across my screen at 718-877-3100. That's the phone number to call if you're in need of legal advice, or if any of the content that I bring to you from week to week is of any value to you. For those of you who are following and supporting the webpage, I thank you so much. I appreciate all of the referrals from some of you. I really do appreciate you. Today, we'll be talking about trust. We're going to be delving into, I've always come up here and I've talked so much about protecting your assets because I know it's very important to protect your assets because those assets are what you're going to pass down from generation to generation. And your children are going to benefit from it. Your grandchildren or whoever is going to come after you is most likely to benefit from any asset that you will work for in your lifetime and leave behind. Obviously, if you're not leaving any assets behind, like some people I know, they've squandered their resources or during their lifetime. I often say you make a woman a millionaire, you make the entire family a millionaire. You make a man a millionaire, and you make everyone else except his own family a millionaire. I often say that because, one of the weakness with men is often women. So that's an issue. But anyway, let's stay on the topic here. Today, we'll be discussing ways to protect your assets through a trust. We'll be discussing a living trust, which is two categories of living trust. There can be a revocable living trust and irrevocable living trust. Today, we're going to focus on the revocable living trust. A lot of people from time to time will ask, what is a trust? They want to know what is a trust. Well, the word itself is kind of like self-explanatory. It means say trust. The word trust implies you need a trustee, and it's you essentially trusting to put your asset somewhere in hopes and expectation that the person or whoever is managing it is going to manage it in accordance with your wills or your express expectation, which will be written in the form of a trust document or a trust instrument. So in this case, we're focusing here on the state of New York. And just so you know, the laws in New York, some of the states are very similar, but I'm not advising you on the other states, but it's also similar. And also, as it relates to British law in Guyana, I know a lot of the people watching the content are also in Guyana, whose law is based off of British law, but the trust doesn't operate the same way in Guyana as it operates in the state of New York. So let's focus here on New York. In New York, there's two types of living trust. You can have a revocable living trust and an irrevocable living trust. The revocable one tells you that, you can revoke it at any time, meaning you can terminate that trust if you so desirable at some point during your lifetime. The irrevocable one, on the other hand, you do not have the right to revoke it at any point during your lifetime. And as we will discuss later on in this program, the limited ways in which the court will allow a person to revoke a irrevocable living trust. But let's go back to the living trust. What do you need if you decide, okay, you have a lot of assets, or in some instances, you don't even have to have a lot of assets to want to protect those assets for those who follow behind you, which are your children or your grandchildren or whoever it is. The thing is, creating a trust is one of the most effective instrument and tool for preserving assets. Because in the instance where a person die and leave a will, you see, your children or whoever you're leaving those assets to will have to probate that will. And that's where somebody like me comes in, because when your children, when you're gone and that person has to probate that will, then I will get paid twice. I will get paid to prepare the will, and then I'll get paid again to probate that estate for you. But you can bypass the second aspect of it if you just put everything into a trust. And in the form of a trust, you can guarantee that that asset or those assets are going to stay and pass from generation to generation, as long as those assets are maybe fully paid off, or in the case of a real estate, or in the case of an investment, stocks, bonds, shares in a on the stock market. Those assets could be passed down perpetually by way of a trust. And for those of you who've gone to Hershey's Park in Pennsylvania, the Hershey's is under a trust, and that trust moves in perpetuity, meaning it could last for many, many lifetimes. So you can have children, grandchildren, great, 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 great grandchildren coming, and that trust will still be alive. The rules of perpetuity doesn't operate that way in the United States as it does under the British system in Guyana. Under the rules of perpetuity, you cannot have a trust that operates perpetual. The trust will eventually die its own natural death. But here in the United States, we have the advantage of having a living trust just go on for decades, from generation to generation. And the trust will basically never die as long as the person who's managing the trust, who is called a trustee, performs his or her function effectively or in an effective manner. So now, what is required for you to form an irrevocable living trust? First of all, you'll have to consult with an attorney. The attorney and you will discuss what are the assets you intend to put into the trust. Now, if you're the person who wants to create the trust, you're called the settler. And then you need a trustee first, and then you need to have the beneficiaries, the object of your trust. Now, first, you're going to select, you as the settler, you could select yourself as the trustee. You could say, okay, I'm going to make myself the trustee while I'm alive, so I will manage the assets. So you can tell the attorney to create the trust, make you as the trustee, and then you could have successive trustee or successor, what is called a successor to you. So maybe a lot of people choose maybe their eldest child, the oldest or the second oldest, or whichever one of their children they know to be very responsible. A lot of people go for that, and they make a child of theirs the successor trustee. In instances, some people have made me as their attorney, their trustee, so that I will hold and manage the property for them. And when anything happens, the property automatically goes to whoever the object of the trust is, the beneficiaries under the trust. Now, anyone you can select as the trustee, yourself, your child, your attorney, whoever you want to make the trustee, you can make that person the trustee. The second thing that has to happen after you select the object of your trust, the trustee, you tell the attorney what are the assets you intend to put under the trust. The other thing you need to do other than those issues is figure out, like, okay, so what do I want to do? How do I want to make this work? How do I intend for this trust to go? The terms and the conditions of the trust. You see, the trust is similar to like a contractual obligation, except it's not a contract. It's just your expressed intentions. You're telling the trustee, the person who's going to hold the trust, either yourself or whoever is to take over after you, these are my intentions when it comes to my assets. My assets include, and you put a list of those assets in the trust. If it's real estate, most people who own real estate, because real estate is one of the fastest way to build wealth. For those people who are interested in wealth building, real estate is one of the fastest way in which you could acquire wealth. And as people know, here in the United States, that was one of the main reasons why Afro-Americans were prevented from acquiring real estate, because everyone knows that real estate is one of the fastest ways for anyone to acquire wealth. So if you got real estate, you're on your way to wealth. If you don't have any real estate and you just have stocks and bonds and investments is a way, it's a very risky way. For instance, you could trade on the stock market. That's one of the riskiest ways. One of the safest ways is real estate. One of the fastest is stocks, but it's also one of the most riskiest. And that's one of the ways that you're going to either really make it or you're going to really, really lose, end up losing everything. So I think a lot of the times when it comes to trust, most of the clients that I've seen are people with property. They have real property and they want to ensure that those real property stays in their family for many generations. A lot of times it's income property. What we consider income property might be a multi-family unit, or it might be an apartment building in which it has several units that are being rented to tenants, and it's bringing income in. So those are some of the things people typically include in their revocable living trust. And some of the terms that the settler would choose in his trust, he's going to tell I've said earlier, he could basically dictate to the attorney he's going to be or she's going to be the trustee in the first instance, and after his or her death, the successor will take over, and the successor will ultimately have to determine what happens to the assets under the trust. So the settler needs to ensure that his or her intentions are clear, that if he or she wants that trust to move in perpetuity, or if he or she wants that trust to end at a particular time. Most of the times the trust could end at the settler's death. The settler could say, okay, when he or she dies, he would like the trustee to take the asset and to sell the asset and to distribute the proceeds equally among the beneficiaries. That's one of the things the settlers could do. But if you would like for this to go on in perpetuity, like I said earlier, and you would like for generations to come, that, your children, grandchildren, everyone, whoever you leave behind is just able to increase the value of those assets and to keep it in the family, then you would want a trust that would remain in perpetuity. As time progresses, the trustee, you could limit the powers of the trustee, or you could give the trustee expansive amount of powers. The person whoever succeeds after you, or even if you say, I want the person to hold the property straight out, I don't want to be a part of it, all the trustee should do is manage the property and give me the income so I can live off of that income for the rest of my life. And then when I cease to exist, then the income should go to my beneficiaries under the trust. Or the trustee should take this asset after that time and just sell it and just dissolve the trust altogether. These are all options. You have a right to choose and sit and discuss with the attorney that is dealing with the trust. One of the things you don't want to do, when you create a living trust, you do not want to leave any of the assets in your name. You want to transfer out all those assets either to your trustee, or in some instances, people create a corporation just to hold those trust assets. They create that corporation, put the corporation as the trustee, and then the corporation now has to have employees managing the trust assets for them. Or it could just be one person, depending on the magnitude or extent of the settler's estate. If the settler's estate is very small, then obviously the settler could still very well create a corporation. But one of the things you need to be cognizant of if you decide that you're going to go with a corporation is that there are several requirements that you must satisfy in any state you incorporate in. So one of the places people tend to go often and incorporate is Delaware because of the tax benefits. But if you incorporate in the state of New York, you must follow the strict requirements as it relates to annual filing. You must ensure that those things are done. Otherwise, the trustee could go dormant. As you know, a corporation is a person. It is dealt with and it is treated just like a regular person. So if you allow that corporation to go dormant, then that could become an issue. So you always have to ensure that you comply with the tax filing, all the requirements to keep the corporation active. That's why some people just choose an individual because it's less expensive, it's more cost efficient, but then you have to make sure that whoever that trustee is, that you can trust that person. Or if you don't feel like you're on solid ground with that person, ensure that you restrict the powers of the trustee. So for instance, under the trust, the trustee has the powers to rent, to sell, to prosecute, to sue, to do anything as it relates to those assets. But if you are not so confident with the person you're selecting to be the trustee, and you fear that the person might go ahead and sell some of your assets or do something that they shouldn't do, then you should restrict the powers of the trustee. For instance, you could make it mandatory that any person holding your assets on as trustee must, in order to sell the properties, must have the consent of all the beneficiaries in writing. If they don't have the consent of all the beneficiaries in writing, then they do not have the power to sell your assets. That's one of the ways to control that and ensure that there's some level of transparency there, that you control whatever the trustee is doing or whatever the trustee intend to do. That's one of the things you can do. And outside of making yourself the original trustee, obviously, because once you're the original trustee, you know for sure that for the length of your life, the property will remain intact. No one will sell it because you obviously are the one who is managing the assets, and you can make that decision whether or not you want to hold on to it for the rest of your life, leave it to your beneficiary, or you want to sell something if you fall on hard times or any of those things. But the bottom line is whoever you're appointing under your trust instrument as your trustee must be a trustworthy person, because that person would have expansive powers to do things with your assets. Okay, even at least an attorney. If somebody makes me a trustee, as the attorney, we are guided by rules, ethical rules, and there's different things that would prevent us from doing things. But in any event, I would tell anyone, if you're going to make any person other than yourself a trustee, make sure you vet that person, make sure it's the right person and you're making the right decision. Okay, now let's focus on your beneficiaries. Now, under the trust instrument, don't forget I said to you earlier, you're going to be naming beneficiaries. Okay, now if you're very specific and you narrow it down to your children, now, obviously, that trust is going to end once your children are the only persons left to become the beneficiaries. And if your children don't exist no more, the trust basically ends because there's no other beneficiaries, and the settlor would have already been gone by that time. So one of the things you can do, you can ensure that you make the language in the trust expansive. If you intend for the trust to go on in perpetuity, make the language so expansive that it will reach children, grandchildren, great grandchildren. If you make it for the benefit of any of your any person who derived from your bloodline, any of your heirs, any of your children, great grandchildren, or anyone in your lineage to come after you're gone, it will obviously have to be that expansive that it will capture people from generations to come. Otherwise, you can forget it. If it's just the children are the beneficiaries, it will expire after you're dead. And then your children who inherit the assets, they will have to either direct the trustee on what to do, or most likely in the trust itself, it will tell the trustee what to do at the end of that point, when it's just your children who are left as the beneficiaries. Most of those trusts says, well, the trustee is going to sell the property and divide the proceeds from the sale of the property in equal shares to all of the children. If that's not done, it can create an issue, or there are other issues which could arise. Like, for instance, a beneficiary could die, and then the question is who inherits if one of your beneficiary dies. And the most likely person to inherit, if you make that trust expansive enough, is the children of that deceased beneficiary. And if there's no children, then it goes, based on the rules that determines intestacy in the state wherever you are. The rules of intestacy usually go to spouse, then children, then if there's no children, parent, then if there's no parent, siblings, and that's how it goes. The order of priority when it comes to the rules of intestacy. The rules of intestacy are only invoked when a person dies without a will, or in this case, the beneficiary under a trust must have had a will, so that if something should happen to that person, then their share goes to their estate and then to whoever is entitled to their estate. I got this question a lot, which is a lot of people are very fearful that they do not want their children's spouse to inherit anything from them. There's a lot of people with animosities with in-laws, with son-in-laws, daughter-in-laws. They have a lot of animosity. You'll be surprised at the number of people who do not want to inherit a son-in-law or a daughter-in-law. In that case, if you want to make sure that if one of your beneficiary dies and they have a spouse and they didn't create a will, and you want to ensure that their wife or whoever survived them doesn't inherit it except their children, you got to be very specific again and said that if one of your beneficiary should die before being able to inherit whatever the benefit is under the trust, then you would revert that person's share back to the other beneficiaries, and it'll just be divided among the surviving beneficiary. Or for instance, some beneficiary predeceases the testator, and that if that person predeceases the testator must either amend that trust, or if the testator failed to amend that trust, then that benefit could lapse if the trust is not expansive enough to take into account that the estate of that beneficiary or the children of that beneficiary should inherit that benefit or inherit whatever it is that the settlor intended to give to that beneficiaries. So these are all things that should be considered and you should take into account before you even get the revocable living trust completed. When it comes to the irrevocable one, the one that could never be revoked, if you decide to do that, most people who do irrevocable living trust is one who has a wife or a spouse, and they both want to pool their resources together into one. They want to do one trust, and it could be called like the family trust. They could name it like whatever their last name is, that family trust. For instance, you could say the Washington's family trust, or you can say the McPherson's family trust, whatever the person's last name is. And those trusts cannot be revoked for several reasons. Because if you have two spouses and they're pooling their resources together, the obvious thing is they would not want, after the death of one spouse, for the surviving spouse to go and change the trust, to revise it, to amend it, to change something in there to benefit somebody else who that surviving spouse might again go and remarry. So that's why if two people together are in a relationship, or husband and wife, and together they build a financial empire that they're going to leave their legacy to their children, then the best thing in that type of scenario would be an irrevocable living trust. So whoever dies first the survivor don't have the right to revise or to revoke or to amend that trust. So in the case of a partnership, husband and wife, married together, or even a civil union, they're living together and they want to do a trust to benefit all of their children, the irrevocable living trust would be the best option for those two people. So when they put their assets into that revocable living trust, both of them will be considered the settlers, and neither of them, whoever survives the other, can never touch that trust for the length of whoever survives last life. But the trust will remain intact, and it will benefit their children. So if they have children together, or they have children separate, he has his children, she has her children, or whatever the family dynamic is, the bottom line is the last to survive will not be able to damage or tamper or to change in any way that trust. Because I've seen this happen many times. I've known of instances, but this was a case of a mutual will. So instead of the parties creating a trust, the husband and wife, they created a mutual will. And in the mutual will, the husband had a child, but the wife never had a child with the husband. So there was just one child involved. The husband died first. So on his death, the wife survived. And the son that the husband had, he was living with his surviving wife. And what she did, she revoked the mutual will. She went and she revoked the mutual will during her lifetime after her husband died. And she changed it that she will benefit her family instead of her stepson. So you see, that's one of the reasons why, with the case of people who are married and they have their separate children or whatever, it's really important that the parties do a irrevocable living trust, so that neither could change it on the death of the other. And in the case, if the man survives the woman, we know that that man is more likely to go and remarry. And once he remarries, his wife might be like, okay, if something happens to you, she might need some sort of protection in terms of financial protection. So she might insist that he should change that trust so that it can benefit her, so that if anything happens to him, she'll have a roof over her head, she'll be benefiting financially. And that's the reason why people in a marriage or people in a relationship union that wants to pool their resources should always go for the irrevocable living trust, because then the surviving spouse, his or her hands will be tied. They will never be able to tamper, to change, to amend, revoke that irrevocable living trust. The only grounds, some of these just limited circumstances on which the court allow for a party to amend or to revoke or to do anything to a irrevocable living trust. And those are your textbook type of reasons, like duress, fraud, undue influence. Those are all some of the reasons. The same reasons that they would use to make a will invalid is actually the same reasons that the court would use to invalidate a irrevocable living trust. That's the one that cannot be revoked no matter what. It has to stand, except, save and except in limited circumstances by an order of the court, based on those limited grounds that I've given you: fraud, duress. If there's any fraud ever in any document, we know it's revoked. The court could overturn it. The court could deem it invalid, and then it wouldn't exist, period. But outside of duress, fraud, undue influence, the limited circumstances, you cannot revoke that irrevocable living trust, and it will remain in place forever for whatever the duration is, based on the way it's worded. And one of the other things that must be done with your irrevocable or your revocable living trust, you must list your assets. There's a Schedule A on those trusts in which you must list every single one of the assets that you would like the trust to capture. If you want the trust to be all inclusive, you can list your assets and all. You can also use language like any other asset that I may have at the time of my death. So you can just make it expansive if you create the trust in 2020 and then you buy a new property in 2024, then automatically, because of the broad language you use in the irrevocable or the revocable living trust, it captures any real estate or any personal property that you will acquire by the time you die. So that's one of the ways you could avoid even having to go back to have the attorney amend it, by having broad language to encompass any property or any asset you might choose to acquire even after you create this trust. And you will never need to go back and pay extra money to have the trust amended. Now, the reason why the trust is always a first choice over a will, like I said, it save your children money, or whoever is going to be inheriting, either your spouse or your children. It saved them money so that they wouldn't have to pay somebody like me twice. You'll have to pay to create the will, first of all, and then again you'll have to go and pay to have the will probated. And a lot of times I've seen in our community, the beneficiaries or the people who are going to inherit that estate, they do not have the money to pay the attorney fees once their parent dies. So what happens? They have to do what is called a contingency fee with the attorney, where they agree that they're going to give the attorney a percentage of the estate once the estate is probated and the assets are disposed of or sold in the case of real estate. So you got to be very, very cautious there and determine which one is better for you. The cheaper option is the will upfront, because the will doesn't cost you much money. But when you're gone, it's going to cost your survivor a heck of a lot more money. For those people who don't just have like surviving for benefits under a 401k or a pension, and you don't have much asset, I guess there's no reason to consider this. The trust is really for people who have assets outside of employment, investment, or intangible assets. So even stocks and bonds, you can name beneficiaries to those. But when it comes to real property, real estate, and you want to benefit people who are minor at this point, the most effective way is to go for a trust. Again, guys, thank you so much for joining me today on this live on the law and you. It's a 30-minute show every Saturday at 4 p.m. And if you have enjoyed the content that I provide for you, I want you to go ahead and smash that like button. And I want you to go ahead also and share the heck out of this live. Share it for me if you want me to continue to bring you content to help you how to navigate the legal system here in the United States, in the states that I usually speak about. You go ahead and share and have your friends and your family share. And for those of you who have been supporting me, I want to go ahead and say thank you so much for all of your support. For some of you who send your neighbors, your friend, your family, thank you so much for all of that support. My phone number is right there if you need legal assistance, if you heard this content and you need anything, any sort of assistance. And I saw you, Keith Beresford, I saw your comment, but thank you so much for sharing the live. And shout out to everyone who have been persistent and consistent in supporting the Washington Law Firm. Thank you so much. I appreciate you. The phone number there is 718-877-3100. Refer your friends, your family, your neighbors. There's so many people come and they say, oh, my neighbor, give me your number. Or, oh, my cousin, give me your number. I know a lot of people call from even in Ghana and they give their family and friends here in New York the phone number. But guys, thank you so much for joining me today. And I hope I'll see you again next Saturday at the same time, 4 o'clock, for the law and you. Have a great rest of your weekend. And thank you so much.